5 seconds to go. Start. In those circumstances, an application was preferred to requisition the said CD, but this application was rejected by the trial court on the ground that the evidence of PW47 had been recorded and a last opportunity had already been given to him to produce the CD. Stop. A single judge of the High Court on 2nd March 2020 allowed the petition instituted by the appellant to challenge the order of the trial court, noting that the CD was a vital piece of evidence and had been provided to all the accused along with the charge sheet. Stop. Resultantly, the trial court was directed to take necessary steps for requisitioning the CD through the police station and for taking it on record from PW47. Stop. Para. On 15th March 2021, another application was moved under Section 311 on behalf of the prosecution for summoning the decoding register. Stop. Para. On 5th July 2021, the prosecution filed an application under Section 311 CRPC stating that the court had taken on record the CD and a certificate under Section 65B of the Evidence Act, in pursuance of the order of the High Court admitting its previous application. Stop. By filing the third application, the prosecution sought permission to summon the certificate issuer and examine said witness in order to prove the certificate. Stop. Para. On 16th July 2021, an application was filed by the prosecution under Section 311 to summon the nodal officer of IDEA and under Section 91 to produce the call data records of two mobile numbers. Stop. Para. On 22nd September 2021, the trial court allowed the third application but dismissed the fourth application. Stop. This order of the trial court was challenged before the High Court. Stop. In the meantime, the trial court by an order dated 13th November 2021 dismissed the second application as well. Stop. The trial court in its order dated 13th November 2021 rejected the application for the production of the decoding register on the ground that, para, the document which the prosecution desired to summon does not form a part of the investigation and the document has not been obtained during the course of the investigation. Stop. Para. Consequently, on the same date, the trial court also recorded that the evidence of the prosecution stood closed. Stop. The appellant challenged this order of the trial court before the High Court, invoking its jurisdiction under Section 482 CRPC. Stop. While rejecting this petition on 8th April 2022 in miscellaneous criminal case number 57152 of 2021, the single judge of the High Court held that the decoding registers are not part of the case diary or the charge sheet, the prosecution has closed its evidence, and the application has been filed at a belated stage without collecting all the relevant information, start, for instance, whether the decoding register is available with the service provider or not, close, stop. Para. Separately, on the same date, that is 8th April 2022, the High Court also disposed of two proceedings under Section 482 instituted by the state of Madhya Pradesh and by the appellant challenging the order of the trial court dated 22nd September 2021 dismissing the fourth application under Section 91 CRPC for summoning of documents. Stop.